Okay, so we were having this foreign judgment part that we will do today. Okay.
Okay.
So this one would take another class. Okay, I thought this we can do, but it is a bit lengthy. So in another class, we will do the remaining part. Today we have foreign judgment, which is nothing but given under sections 13 and 14. There are just two sections which we have. Now, when we talk about foreign judgments, why is it becoming like important nowadays? Is because like this concept was there even before, right? These are not amended provisions. These were there originally also in the legislation. If we look at it, right? Section 13 and 14, these are not amended provisions, but these were there since the starting itself. But nowadays, why it becomes even more relevant or even more important is because now more and more people are living outside the country also, right? So when we talk about national laws, these are applicable or these are enforceable within the country itself. If you look at the scope or application, like we discussed in first class also, it's applicable in India. There are also few parts like Nagaland and all those are excluded. That's why foreign judgment becomes relevant. Because of globalization, there may be more and more people living outside, and foreign legal materials are now easily available due to communication and all the technological developments which we have. Earlier, it was very difficult to know what laws were applicable in a certain country. Might be even if we get to know what laws are applicable, it was very difficult to get details on the day-to-day proceedings of court. But now it has become so easy, right? Even what is going on in foreign courts, we come to know that, right? If there is a dispute wherein Google was involved, it's some other foreign country, we get to know it. There was some agreement between Amazon and another one, we came to know about it. It's all because of the improvements in the communication and technological fields. Plus, if we have the details, right, like now courts are also coming online, their records are being kept online, we can easily download copies of the records and stuff, right? Just we need case number or maybe names of parties, we can easily access everything. Even during COVID, you must have seen there are YouTube channels actually for Gujarat High Court and some other high courts where entire proceeding will be recorded. You can see what is going on inside the court, even without going there. So it has become very much convenient that we can access foreign judgments very easily, very quickly. Now, what is foreign judgment and what is a foreign court? These two words are defined in CPC. Like we mentioned in first class also, mostly legislation should provide for certain definitions in the section 2. Okay, section 2 would be interpretation or definition clause, wherein certain words will be defined which we will be using in future in the legislation. There we have definition for foreign court as well as foreign judgment, which becomes relevant for us. So section 2 clause 6 of CPC defines foreign judgment. So what is foreign judgment? It is as simple as that, judgment of a foreign court, not given by an Indian court. Then it even provides for definition of foreign court in section 2 clause 5, wherein it says a court which is located outside India plus which is not established or continued by authority of the central government. It is not there in India, plus it is not under the control or authority of the central government. Okay, it is under some other foreign country's jurisdiction and it is established based on their rules and regulations. Okay, so when we say authority of central government, usually there will be a legislation for this as well, right? Different courts which are being established. right? These courts are not established simply like that. There will be a legislation for that. Like if you look for high courts, okay, under which legislation was Bombay High Court established, under which legislation was, like Madras High Court established. We get the details. And there we can see powers, functions, and so many other things. And it's not just about one legislation. There are actually multiple legislations that provide for rules, regulations, powers, functions, and so many things of these different courts. Okay, so whatever is established under the control or authority of parliament or any state legislature, that will be considered as Indian. Something else, it will be considered as a foreign court. Judgment given by such court would be a foreign judgment. Now, the basic principle which is followed while enforcing a foreign judgment, that means we can even enforce a foreign judgment. Some judgment is being given and certain rights or something is mentioned by the court. Okay, that this person would get so much of compensation, or such an injunction order has been passed, or court may nullify certain arrangement between parties, certain agreements. All these we can enforce as well. So enforcement of foreign judgment or decree in India is to ensure that judgment and decree is conclusive one. We can enforce it. Maybe parties were residing outside India for some while, they obtained a decree, but after that, because of COVID, they moved to India. Now they want to enforce that decree because they already spent a lot of money, lot of time, effort, energy, everything in getting that decision. So now if they want to enforce it in India, it has to satisfy three things. Okay, there are three things that needs to be satisfied. That it has to be conclusive one, it has to be decided on merits of the case, and it should be decided by a court of competent jurisdiction. Okay, these are the three things that needs to be satisfied. After that, parties can enforce a foreign judgment as well in India. That judgment also would be given importance, that will also have validity, even though it was given by a foreign court, it's a foreign judgment, that also will have validity in India. Okay. This part is clear, right?
Yeah. It can be any location, but just outside the India, right? That is what
outside the India. Yes. Outside the India. Outside India, plus also outside the authority of central government, because sometimes it may happen that, okay, fine, like there would be some these, right, embassies would be there, right, that for India there will be people in every single country to take care of the Indians who are residing there. Might be they would establish some, like redressal body or something. If people are not satisfied with the decision of embassy, they can go complain somewhere. If at all something like that is established, that body would still be under control of India, right? India has established that this, so that is not foreign court, but otherwise whatever is outside India plus outside the control or authority of India, that will be included. This provision just mentioned that if in case there is something like that established. Okay, now provisions related to foreign judgment. We have two provisions, section 13 and 14. Section 13 talks about when foreign judgment not conclusive. As in, from a foreign court, you might have obtained a foreign judgment, but that judgment would not be conclusive. That judgment would not be considered. You cannot ask for its enforcement. Okay, so section 13, I have just put some explanations for each of the points. So we will discuss from here. Okay, a foreign judgment shall be conclusive as to the matter thereby directly adjudicated between the same parties, or between parties under whom they or any of them claim, litigating under the same title. So what does this mean is, even if there are two parties who were disputing with each other, and they obtained a judgment or a decree from a foreign court, that judgment would be considered as valid, binding, or conclusive. They can even ask for its enforcement. So it says a foreign judgment shall be conclusive. Okay, so even if parties have obtained a judgment from a foreign court, that judgment would be considered as conclusive, as in it's like a complete judgment that we can accept. But when it will be considered as conclusive, as to any matter thereby directly adjudicated. Okay, for some kind of a matter, for some sort of a dispute, which is directly adjudicated between the same parties. If there is a dispute between you and me, okay, we both entered into a contract, then we move to some other foreign country. Okay, so there is a contract between you and me, which was entered in India, and Indian laws were otherwise applicable on us. But because both of us moved to another foreign country, maybe we moved to USA. Okay, now what laws would be applicable on us, because we don't have the accessibility to Indian courts and there is breach of contract. So what we decided is we went to a court in USA, got a judgment as well for that matter. Now this judgment, whatever the court of USA has decided, that judgment would be considered as conclusive. It will be considered as valid. That's something which can be accepted. But it will be valid only for matters which are directly adjudicated between us or between parties under whom they or any of them claim litigating under the same title. As in, it may be just you and me. It may be that we are nothing but two agencies. So we have our representative, we have other people. So it may be all of them together, or it may be just individually you and me. Okay. When we have obtained a decree, when we have obtained this judgment is binding only in terms of this matter which was decided, only for this certain contract. If there were 10 other contracts that we had entered in India, and now from USA we are back in India, now if there is breach of contract, we cannot say that in this decision US court had said this, so it should be applied here. No, precedents of Indian courts should be applied. So this judgment, what we have obtained from USA, it will be valid only for that specific case which was decided. Okay, is it clear?
Yeah.
Okay, it's not confusing, right?
No, yeah, it's clear.
So that is like the basic thing, that okay, in such case it would be binding, but except, as in there are certain situations wherein such judgment will not be conclusive. Even if we have obtained a judgment, that judgment will not be considered as like a valid one. It would not be enforced. Okay, so what all those situations are, that is explained in section 13. So otherwise it will be valid for that specific matter which was decided by a foreign court. We got a foreign judgment, but it would not be valid in many other cases. What all many other cases? There are 6 situations explained that we need to see. First of all, where it has not been pronounced by a court of competent jurisdiction. Even though it's a foreign country, it's a foreign court, jurisdiction is very important. Okay, if the matter was maybe related to contract and we are going to some court like a magistrate court or something, right? So in US, even if the matter was decided in US based on their laws, or it has to somehow relate to Indian thing also. Okay, it should not be like some random court we went. Okay, it should not be like a court of maybe like which is established for regulating child labor or something. Just because we knew someone from that court, we cannot just write, like get like a written copy that okay, fine, make this contract enforceable. That should not be the case, right? Even if it's a foreign country, foreign court, we need to ensure that we are going to a court which is having competent jurisdiction to decide such matters. If it's a contract, maybe we would go to some civil court there, but we cannot go to a board or a commission which is established to regulate child labor over there, right? In such cases, Even though there is a judgment, that would not be conclusive. That is the first situation. Okay. So sometimes what may happen, right, unless the court has jurisdiction. So there was this case wherein, okay, the point established in this, okay, there was a dispute between, in the basic principles, the judgment passed or any matter adjudicated upon the court has no jurisdiction, it will be considered as null and void. It is as if that judgment do not even exist. So the Supreme Court held that unless the court has jurisdiction, delivered by the court would not be recognized and enforceable. Unless and until it is not like a valid court having jurisdiction, the judgment would be considered as null and void. As if it do not exist, we cannot enforce that as well in the court in India. Okay, so that is the first thing. The jurisdiction is very much important. Secondly, it says where it has not been given on the merits of the case. So a case can be said to be decided on merits when judges would take all the evidences, whatever steps need to be followed. It is done in a proper way, right? After taking everything into consideration, the decision is given by the court. In such cases, we would say that this case is decided on merits of the case. Everything was taken into consideration, and after that, finally, a judgment was given. So if it is not decided on merits of the case, simply because maybe you knew someone in that commission which is established in USA for controlling child labor, you went to the commission, you met the chairperson, and chairperson wrote something. That is not acceptable, right? Because it is not given on merits of the case. They did not even see the evidences and other stuff. But there may be some, have you heard this word exported?
Which few they are going to send it out, I think.
Yeah, yes.
You have heard, right? So there are many situations wherein court would give a date that on this day you have a hearing or you have this, that. But yeah, like parties might not be available every single day, right? Parties might not be available and the advocate might not be available. So sometimes you would ask for like another date, that today I'm not available, give another date, give another date. But sometimes what happens is this thing may go on and on for like forever. It mostly happened during COVID. What happened is judges would give a date, they would be sitting for this Zoom link and everything, they would open, they would be sitting, but nobody, not even the advocate, not even the parties, no one would appear for that matter. Judges would give another date, nobody appearing, another date, nobody appearing. After a certain point in time, what they would do, they would either dismiss the case, that none of, like no one is appearing from both the parties, neither the parties nor the advocates, no one is appearing, let's dismiss the case. Sometimes it may happen that only one of the parties is appearing every single time, this other party is not there, they have not informed anything also. In such cases, ex parte decision may also be given, as in hearing one side, decision would be given. So just because, okay, it needs to be noted that a decree being ex parte does not necessarily mean that it was not on merits. Maybe evidences and everything was done, after that party stopped appearing. Just because it was an ex parte decision, it does not clearly indicate that it was not given on merits. So we need to see under what situations or circumstances decision was given, and depending on specific situations of the case, we can decide whether case was decided on merits or not. If on merits, fine, it's valid. If not on merits, then it is not conclusive. Okay.
One doubt, what is the prerequisite if I need to approach for a foreign judgment, right? It should be the resident outside India, or
yeah, you can be a resident outside India. Sometimes what happens, right, like due to these business transactions and all, there, like most of the companies would have their foreign clients, right? There they would enter into contracts. So in that case, it's not like the company itself is moving there or companies having some head office or branch office there. It's just a service that they are providing to a foreign client. right? There, what happens is like which country's laws to follow, because it may be India providing a service to US client. In that case, in the agreement itself, they would write that in case there is a dispute, we would decide the matter based on this country's laws or that country's laws, or we would decide the matter based on, like this arbitration thing. So what have they mentioned? If they have mentioned that, okay, fine, we would agree based on whatever US court would say, we would take that decision. In that case, whatever US court is saying, that also becomes a foreign judgment itself, right? That can be enforced in India as well. So there may be multiple situations wherein this thing happens. Mostly it may be in case of this private relation between people. Yeah, maybe the parties moved to a foreign country and there it is happening. Nowadays, this divorce and other things, it's happening too much. That parties would get married in India based on the Hindu, Muslim, whatever laws, like Indian personal laws, they would move to a foreign country and there things are not working out. They would get a judgment from there. They would want to dissolve the, like marriage. Those situations are also very common.
Okay.
Yeah. Basically, it's not like we have like a hard and fast rule that this has to be there, but whatever happens. After that, court would see if it was valid or not, what situations were there, because there may be multiple possibilities. Okay, court would see and decide whether they want to entertain it or not entertain it. Next one is that where it appears on the face of the proceeding. Okay, on the face of the proceeding, when we see the case, that time itself, it's like very much clear. On the face of it, to be founded on an incorrect view of international law. There are certain principles which are established, right? At international law also, there are certain principles which are established. It is like completely against that established provision of law. Okay, like what is established? That whoever is the victim, whoever is suffering, that person should get compensation. But if you are giving compensation to the one who is doing wrong, that is something which is like completely an incorrect view, right? It is going against this established principle. So when we look at the proceeding and we are very much clear, like what is this? What sort of a judgment is it? Right? That sort of a situation. Or a refusal to recognize law of India in cases in which such law is applicable. Like I said, in case of divorce, because in India we have these personal laws are so much, like given importance, that marriage, divorce, child custody, inheritance, succession, all these matters are decided based on personal laws of the parties. In such cases, when there is such a well-established law that law is applicable, if a foreign court completely ignores the laws of India and gives a decision, that also may be something which is not conclusive. Okay, take for example, in India, we have these concepts called, like in case of Hindus, okay, you cannot get married to more than one person. For validity of marriage, there is one condition itself, that both the parties to the marriage should not be having a living spouse. That rule is very much well established. But if a foreign court says that, and if like second time you are getting married when you already have a living spouse, that second marriage is not valid. That rule is very much established. Now, if parties go to a foreign court and foreign court says that no, first marriage is not valid because you are not liking her anymore, second marriage is valid. So those sort of situations should not happen, okay, when it refuses to recognize the law which is applicable in India, because that is making more sense, right? So in such situations also it would be considered that this is not conclusive, that's not valid thing. Where the proceedings in which the judgment was obtained are opposed to natural justice. So there is a concept called natural justice, okay, which is based on like 3 grounds. Okay, and it is very important that natural justice, like principles of natural justice, okay, principles of natural justice. So it's very important that in any given case, these principles of natural justice are being followed. So what are these principles? Basically, there are just 3 principles. First one says, okay, these are the 3 basic principles. First one says, hear both the sides. When there is a dispute, we need to hear both the sides. After that only we should give a decision. That is followed in India like very much, right? Even you might be remembering this Kasaf who was given death penalty for Taj Hotel attack, Mumbai, right? It was, well, it was like very much clear, right, that this is the person, he is the terrorist who attacked. But even after that, he was kept in prison. He was given so much of security and everything. So much money was spent in maintaining him for this entire duration of trial. And after that, he was given death penalty. Why? Because we follow principles of natural justice. Does not matter what, both these sides would be given the opportunity to speak, to prove their point. That's the first thing. Second thing is, no one should judge his own case. If there's a dispute between you and me, and if I am to give a decision for that, definitely my decision will be biased towards me, right? I will always think that I'm only right. So no one should judge his own case. It has to be decided by someone who is an unbiased person. And third one is reasoned decision. Even though a person is a judge, having all the experience, qualification, skills, still, judge also needs to provide justification or reasons as to why he has given that decision. Okay, when you read a judgment, you would see, because it happened like this, because it was said like this, because we have this law, I'm giving this decision. So judge would also justify why he has given that decision. So these are 3 things which are very important principles of natural justice that needs to be followed. Okay, so if there is a foreign court which has given a judgment and these 3 principles were not being followed, that certain judgment would also not be conclusive. That would not be accepted, because that is not like a proper judgment given, basically. Okay.
Reasoned decision.
Reasoned decision as in, after hearing both the sides, after everything, taking evidence and everything, judge will give a decision. But that decision, why he has given it, reason has to be given. Okay, that is why reasoned decision. Reason also should be mentioned. Next is where it has been obtained by fraud. So when we say it has been obtained by fraud, as in parties maybe submitted some false evidences, false witnesses, fake witnesses and stuff, and parties tried to mislead the court. In such cases also, we would say that this is not a conclusive judgment because it was obtained by fraud, right? So that definitely is not valid. So decree or order obtained by practicing fraud on court or authority is null. It's like null and void. They do not exist in the eyes of law. They are non-asset. They do not exist in the eyes of law because it was obtained by fraud. And last one is where it sustains a claim founded on a breach of any law in force in India. So foreign judgment in breach of the laws in force in India also is not conclusive, and it is considered being null and void. The objective of this clause is to ensure that no foreign law can offend the public policy of our country. So the decree for divorce, which has been passed in a foreign court, cannot be enforced in India if Indian law does not approve such a divorce. For divorce also, there are certain grounds mentioned. Parties cannot just go to the court and be like, okay, yesterday I got married, today I want divorce. There is a certain process which needs to be followed. Parties need to live for a certain while. They need to live separately for a certain while. So many other things, right? There are certain grounds also. Based on those grounds, only parties can apply for a divorce. So just because parties were living in a certain foreign country and they obtained a divorce decree, that they cannot enforce here. Okay, if they want to enforce it in India, they want to say that, okay, fine, this marriage is dissolved because this is the decree. Indian court would say that we cannot enforce it because we do not even recognize this sort of a divorce. That ground of divorce do not even exist in India. So we cannot enforce it. That is when again it would be said that this certain judgment that you have obtained, this is not conclusive. That is all about section 13. Is this part clear?
Yes, ma'am, that is clear.
So there are 6 points basically. If these points are there, it is not conclusive, otherwise it will be conclusive. It can be enforced. Section 14 is on presumption as to foreign judgment. So the court shall presume upon production of any documents, okay, if parties are going to the court and saying, see, this is the certified copy of judgment that we have obtained from so-and-so court of so-and-so country. If they are producing the certified copy before the court, then like the normal situation is that court would assume that, yes, you have obtained this judgment from a foreign court. This is like a correct copy only. That such judgment was pronounced by a court of competent jurisdiction. They would also assume that, yes, you have obtained it from a court of competent jurisdiction, unless the contrary appears on record. Unless and until there is something like they would see that, okay, you have obtained a divorce decree from a certain commission which was established in USA for the purpose of regulating child labor. How does that make sense? Right? So on the very face of it, it is not making sense. In such cases, it's different. Otherwise, court would assume that, yes, it is obtained from a court of competent jurisdiction only. But such presumption may be displaced by proving want of jurisdiction. There will be 2 parties, right? One obtained a judgment. If the other party was unhappy with the judgment, that party can try to prove that this judgment is obtained from a court which is not having competent jurisdiction. Basically, any of those 6 points which are mentioned in section 13, right? The other party can try to prove any of those and say that this judgment is something which should not be enforced in India because it is falling under any of those grounds which are mentioned in section 13. Okay. There was this case wherein a wife filed a petition for judicial separation. Okay, and she also asked for maintenance from Indian court. So she approached the Indian court, filed a case for judicial separation plus maintenance. And when this petition was still there in the court, husband already obtained a decree of divorce from USA. So here the question was whether this decision which was passed by court of USA, whether that decision is binding or not. So in this case, it was said husband and wife are Hindus and their matrimonial disputes are governed under the provisions of Hindu Marriage Act 1955. Plus, wife did not submit to the jurisdiction of USA court, nor did he or she consent to get a decree of divorce from USA. So this decree that the husband has obtained from a court of USA is not recognizable plus not enforceable, because it was not like both of them were living in USA and wife also was like, okay, fine, we should be, like going there and filing the case. It was not like that. Husband only filed the case over there. Wife did not submit to the court of USA. So in such cases, it would not be considered as a valid judgment, even though husband has obtained for that. Okay, so if the party is not happy, basically those section 13 provisions are there which can be proved by them. Okay, is it clear?
Yeah. Section 14
Section 14 basically is that unless and until you are proving it, court would usually assume that yes, this judgment is a valid one, coming from a court having proper jurisdiction, it was decided properly. Because court do not have that much of time, right? Because every single country is having their own specific sort of structures in terms of courts. Okay, they are given different powers. So it might not be practically possible that they have knowledge on all the courts of all the different countries, or they get that information. So usually they would assume that yes, this is coming from a proper court having proper jurisdiction, properly decided. If not, the disputing party can prove that. And if it's proven, court would not enforce the judgment basically.
Okay.
So section 13 provides for the 6 grounds where judgment is not conclusive, and section 14 says otherwise court would assume it to be proper unless and until those provisions are proven. If proven, court would not basically enforce the judgment. That's all about this section. Section 13 and 14, foreign judgment that we have. Okay, fine then. So in the next class, we'll continue with the remaining provisions. Okay.
Yeah.